There we go.
All right. Oh, it's 7:30, so I want to welcome everybody. Thank you for attending our special guest webinar today with Seth. He is part of Brightside Law Group and, of course, talking about special education law tonight. So I applaud everybody for taking the time to be here tonight to learn more on how to really support your child the best that you can, right? The more you know, the better the decisions you can make that are best for your family. That's what I think. And so for those who are new to us, my name is Amanda. I'm the regional director for Brain Balance of Greater San Diego. We have 3 centers in the area, one in Carmel Mountain Ranch, our main center, and then 2 satellite centers, one in Chula Vista and one in Encinitas. And we serve pretty much all ages from starting about 3-4 years old all the way up to 92 is my oldest student right now. So we work with all ages, kids, teens, and adults. And essentially, we typically see those who have goals to improve areas like their ADHD challenges, like focus or executive functioning. We see those who struggle with mental health, whether it's anxiety or emotional regulation. We also see those who struggle with learning disorders or the challenges that we're going to talk about today. And so I'm not sure how in depth we'll go in today, but please ask your questions. We are available as a resource, brainbalancesandiego.com. You can message me directly as well. And then Seth will take over and introduce himself in a moment. Just some best practices again. We're going to be recording this, obviously, as well as following up with everyone with the recording. And I'll be typing in some of the highlights from each slide or so in the chat box as well, so you can reference that, okay? So Seth, we're so grateful to have you spend your evening. I know you're a busy man. You have some young kiddos at home. So I want to make sure we respect your time and really help you feel welcome in this really special topic tonight. That's your expertise.
I certainly do feel welcome, and thank you very much for having me. Amanda, I appreciate you, calling me out and saying that this is information that would be useful to the community. For those of you who have attended a presentation in the past, I spend a lot of time educating families. It's really important to me. And one of the things I really like to do is to provide a broad sense of how this operates. And I'll talk about why that's important in just a few minutes. Tonight's presentation is Special Education Law, Understanding IEPs and 504 Plans, Parental Rights and Resolving Disagreements. And these are paired together because parental rights are, this piece that's so important about being involved, but often it can get messy if a family feels they haven't been heard and lead to disagreements. And sometimes those disagreements can be difficult to resolve. So that's why I've paired these subjects together. Amanda's asked us to talk a little bit about 504 plans. This slide shows really geared towards IEPs, but as I go through, I will remember to bring it back to the 504 plan as much as possible and explain some of those differences. So if you're a family with a 504 plan, you can understand the benefits of going to an IEP or why you might want to stay on a 504 plan as well. With that said, a little disclaimer, I'm a California attorney, so a lot of what you're going to hear tonight is based on my understanding of California law and how it applies to schools in California. There is a federal overlay that sets the standard for what special education is. I shouldn't call it an overlay because California is really truly the overlay to the federal law. And then there's, of course, policies and procedures which individual schools have to fill the gaps where the law doesn't necessarily tell us how things operate. And with that said, all our kids are different. So even if you have a really straightforward sounding rule, you will not cross this line. That crossing that line may depend on the individual as well, how fast they walk, whether they have difficulties doing certain types of things that would make that a different type of challenge. And so you should never rely on what you're hearing tonight as specific advice or an opinion about your own child. You should really go seek an advocate to help you with IEP meetings or an attorney to help sort out disagreements that you might be having. So this is not specific legal advice. With that said, thank you, Brain Balance, specifically Amanda. I appreciate you having me this evening. I am Seth Schwartz. I'm a special education attorney, and I've been practicing for a little over 12 years now. During law school, I worked as an intern for Thomas Nelson, who is a mediator with the Office of Administrative Hearings with special education. And my own personal experiences, I have a sister with autism, and I've been around this pretty much my entire life that I can remember. A little housekeeping, we have a chat and a question and answer box, so you can put your questions that we can get to later into the Q&A. If something seems applicable, I'll do my best to answer it as we go, but whether you put the question in the chat or the Q&A, I just want to ask you to put one in and then hit enter. If you do it in multiple parts, it may be hard for me to identify the actual question because it may be separated by somebody else's comments. We do have some questions that we received prior to the evening. I'll do my best to address those as we go, but if I miss some, Amanda will help me pick those up at the end. So we'll look at IEPs and 504 plans. Let's give a starting conversation about general distinctions. So what is a 504 plan? A 504 plan is sort of our first step into special education when the need is not as great as needed for an IEP. The biggest distinction is that it starts at general education. It is accommodations and modifications. You also have accommodations and modifications in an IEP. So it's not simply that you have to have a 504, and if you want the goals, you'll get an IEP and you'll still have a 504. Typically, when you have a 504, you go to an IEP and you lose that 504 because all of those things transfer over and some. So when you request special education, a lot of times, if the school doesn't feel that a student qualifies for an IEP, they may offer a 504 plan. But a plan is a really great word to start thinking about because in order to plan, you need good information. And the federal regulations actually say that for a 504 plan, you should be assessing as well. How are you going to determine if you meet the eligibility standards, which is a lower standard than you would take to get into an IEP? But at the same time, you still need to know if you're there. So in order to plan, you need information. I like to think of a 504 plan and an IEP as sort of a fork in the road. And in order to figure out which direction you're going to take, you need to have an assessment. So if you're asking for special education or even a 504 plan by itself, in a sense, you're asking to be assessed for the need for special education, and it could be an IEP. When you make that request for special education, you should always do that in writing, and you should always ask for assessments to determine what is necessary for the student's needs. So how do you assess student needs? Typically, a psychoeducational evaluation that's looking at academics because you're dealing with educational environments and you need academic information as well as processing, maybe behavioral issues. If a student's coming with some speech needs and the school's aware of that, has reason to suspect a need in that area, they're going to be required to assess the speech as well. You might have occupational therapy and so forth. But again, a 504 plan is about accommodations and modifications. An accommodation could be a calculator for math. A modification could be reducing the amount of work a student does in their general education course. But if in fact they need to work on something like understanding the letters of the alphabet and they're a couple years behind, they might need something more substantive like a goal in order to work on that. And that would differ from a 504 plan. So why is it important to learn about the law? Over the years working with families, a lot of families look for the law that applies to their situation. At the time, we're frustrated, we've experienced something we haven't experienced before, maybe we're surprised by something somebody said to us, and we go searching online. It's important to learn the law just like you learned about driving a car. You read a book, you took a test, you had to take a driver's test on top of a written test. You learn that you stop at a red light, slow down at a yellow, and go through a green. But nobody really teaches that in special education. So why do you need to learn the law? You need to learn how to drive around the streets, what double yellow lines you shouldn't be crossing. You should learn the roles that people have within the IEP process and with the 504 process so that you can navigate this. And if other people are not navigating it correctly, you should be equipped to recognize that so you could figure out where your concerns lie. And additionally to that, you don't want to get caught up in things that don't help your son or daughter. You want to find the things that are meaningful, and you want to stick to the things that you know you're working towards. And if you get caught up into something where perhaps the school doesn't have a legal obligation to do, you may be finding yourself fighting for months for something that isn't legally required from the school. So it's important to understand the law, learn that framework, and go in educated to how the process works. So when I think of an IEP, I usually break it down into these three pieces: planning, procedure, and implementation. Planning is the actual planning of the document itself. Procedures, those are the things that we need to ensure that that planning's done correctly. So for instance, a procedure with the IDEA is that you're going to have a meeting at least once a year annually. And every 3 years, you're going to have a triannual so that we get the latest and greatest information about that child. We have standards for assessing. We have certain requirements of people that work with the student. Those are all procedural requirements. And then we have implementation. Implementation is we've got this great offer that's on the table about what we're going to do for the student. Well, now we have to carry that out. We can't just simply, have a great piece of written work. Everybody signed and consented to it, but we don't do anything with it. And the procedures there are to protect the planning, and the implementation is to ensure the plan happens so that when we get back to that process the next year, we're ensuring that we're updating and moving forward with that. And with that said, each of these actually have a different rule. I like to think of them like the red light, yellow light, green light. Each one has a different rule. Planning, if there's something wrong with the planning, it's going to be considered wrong. Procedure, if you miss a deadline, like holding a meeting within 30 days of a parent's request, you're going to actually have to show something extra, not just the missed date, but also some impact on the parent's rights to participate in the process, or possibly the student's ability to receive services, or the parent's ability to advocate for that student's needs. If you're talking about implementation, you're looking for what we call a material failure, sometimes defined as more than a slight deviation from the IEP. But what you're really looking for is something serious. You're not looking for a speech pathologist that missed a session because they came to work and had a flat tire on the way and they were late. You're looking for something that happens over and over again, or the failure to actually have a speech pathologist at the school and the student loses 3, 4, 6 sessions. So a material failure. But what's the policy behind the law? Whether it's a 504 or whether it's an IEP, the policy behind the law is access to education. We want to ensure that the student can do what they have the potential to do. But that doesn't mean that they're going to meet the expectations of a general education class. There's a bit of a presumption that with accommodations and modifications under a 504 plan, that will happen. But on an IEP, if a student is 8 years behind in the 10th grade, that student, may make very minimal gains in terms of the IEP speed in comparison to their typically developing peers, but that might be their potential. The law wants us to ensure that they get access to what they're capable of doing. There may be barriers to that access. They might be behavioral. They could be communication, perhaps sensory OT needs. And so we want to address those needs in order for that student to access what they're capable of doing to the best of their abilities. Parental participation with an IEP is very important. Parents are considered a fundamental part of this process. A parent knows the most about their child. They live with their child. They understand everything that they've heard from doctors. They see the nuance of behaviors. They understand how to interact with their child. They know what works and doesn't, to put it bluntly. And parental participation under the law doesn't always feel like parental participation. The basic part of that under an IEP is notice and opportunity. The idea is that a parent gets notice of an IEP meeting within a reasonable amount of time that they can attend, and that they're given an opportunity to ask questions. So in theory, if a parent has reasonable notice and they show up at a meeting and they've had an opportunity to sort of pick through and ask questions about why the school is potentially offering something, or if there are other options available, well, that's a situation where they've had an opportunity. Now, if a parent decides not to ask the questions, maybe the district leans over and says, do you have any questions? Well, they've still had that opportunity. So to get to the other side of what's not an opportunity, we'll talk about predeterminations. But the important piece here is that the ultimate decision-making authority lies with the educational agency, whether it's a district or a charter school or so forth. And that decision-making authority means that the school has to make an offer to the parent that the parent can consider whether or not they want to provide consent to. And consent just means that a parent is giving them permission to carry out the plan. And under California law, they cannot carry out that plan without the parent's consent to that IEP. So how does a 504 plan address parental participation? Parents have a right to participate. They have meetings, but it's not as stringent as an IEP. There is no guaranteed notice of opportunity. The ability to enforce it is not the same. We'll talk about that towards the end of the presentation. So you get a lot more participation in an IEP, but to be fair, it's a bigger document. We're working with goals, not just accommodations and modifications. We're defining the student's needs and the present levels of that IEP. We're determining the levels of service that are going to be necessary in order to meet the goals. It's a bigger process. But a predetermination can be to all of the IEP or just part of the IEP. And a predetermination is essentially the school coming in and saying, this is all we have to offer. You have to take this or leave it. That's not the same as saying this is what we think your son or daughter needs for their education, to access their education. And because of that, a school can draft an IEP prior to a meeting and come in and say, this is what we're thinking. What they can't do is, if you ask a question, why are we, thinking that 20 hours a year of speech is appropriate? And the school says, well, that's all we offer, 20 hours, and we're not going to go any higher than that. That would turn it into a predetermination. But on the other hand, if they say, well, can you tell us what your concerns are? We'd love to hear from you. Do you feel like we have enough goals? Have we described communication well? These are the type of things that would take us away from that predetermination. And that predetermination can be towards services. More commonly, people think about this as placement. My son or daughter has behavioral issues. They need a mental health treatment program that might be in a day treatment setting, and the school just offers that. And they come in with that, and they're very fixated on it. When the parent says, can we look at gen ed? They say, no, this is what's right for your child. That might sound a little bit like it's not a predetermination because they're making an offer, but they're not willing to discuss the rest of the options and why they might work or might not work. So parental non-cooperation is a term that comes up in our cases a lot. And I like to bring it up when I talk about IEPs and how parents involve themselves in the process, because a lot of times parents stand in the way of the district's obligation. If you remember just a moment ago, I said it is the district's obligation to make an offer. And say if a parent walks out of an IEP meeting, which is a very clear-cut sort of way of saying, I'm done here, not happy with the way this is going. Well, that is a very specific way of saying, I'm not going to let you work through this and get to an end result. That would be interfering with that obligation. They have the obligation to make that offer, but they're supposed to do it with parental participation. So if they don't have the parental participation, they can't really get to the end of the offer. There are some exceptions to that. There are some ways that a school can hold an IEP meeting without a family, but it's a lengthy process and it's not the subject of tonight's conversation. So impeding the process of getting to an offer would be viewed as a parental non-cooperation. Impeding the implementation of the IEP could also be perceived as non-cooperation. When we say are uncomfortable and don't feel safe bringing our child to school, and as a result, they cannot implement the IEP. Consent can sometimes have an effect on implementation that could be perceived as a parent not cooperating. So an example might be if they're increasing services, but a parent still wasn't happy, so they didn't consent to the increase. It's possible a court could come back and say that there's no remedy for the increase because a parent stood in the way of allowing the school district to provide the additional services. And And the real question is reasonability under the circumstances. So really, if you take away anything from this, particular slide, I would just say that when you're in these meetings, when you're writing an email, when you're talking to somebody at the school, just remember that you want the perception to be one of reasonableness, that you're the most knowledgeable person in the room, and that's why you're at the table, that your questions and the information that you're providing makes sense, and that you're giving them access to information so that they can do their best job. And, in terms of outcomes, parental non-cooperation can impact outcomes, relationships. Obviously, if you're fighting with people in your IEP team that you have to work with year after year, if somebody shuts down and they don't do their best job, the only person that loses from that is the student. Educational agencies have some obligations to file cases against families. It's not against the parents or the student directly. What they're really doing is they're asking for the court to do what the parent won't do. So the most common types of complaints that schools do are, we would like permission to carry out this IEP. We made an offer we believe is defendable, and the parent won't sign it. Similarly, we believe assessments are necessary. So we're going to go to court and have a judge say it's okay to do those assessments. Or in some cases, there's independent educational evaluations, and a school may file when a parent asks for one because they believe that what they did was appropriate. So they're going to court to ask the judge to give them a stamp of approval for the assessment that they did, in order to not have to fund an additional assessment based on an assessor that the parent chooses. The other thing that can happen are delays. If you spend a lot of time asking a lot of questions, even if they're really important, and you get stuck maybe on a goal that you don't feel is measurable, and let's say you spend 2 or 3 hours on a goal and the meeting can't finish up that day, and it goes over another month, those delays impact outcomes. So it's always mindful to think, am I getting in the way from them making that offer? And if I am I delaying that because I want that offer? I want to see where our differences lie, not right now, but at the end of their offer. I can say, wait a sec, I talked a little bit about the speech, or I talked a little bit about the counseling, but now I actually just don't agree. So let's talk about why I don't agree. If you wait till the end to do that, then you get to dispose of all the other things that you agree with without having too much discussion about it. And then, of course, there are limitations that come through that. You don't want limitations placed on parents. As a parent, you want to be able to come onto campus. You don't want rules placed on how you interact with staff. But there are situations where schools can do that if they feel that the parent is interfering, or they think that something is going wrong and feel intimidated, or something of that nature. It's not that common, but it comes up. So it can go from good to difficult to really bad if you're not careful with that. And it shouldn't be something you need to think about. This is a very emotional process for a lot of families, but I want you to have that in the back of your mind. You're looking for reasonableness because you want to be seen as this contributor, that you're very reasonable, that you're asking a lot of questions. And at the end of the day, you're allowing them to get to the offer, even if you disagree, so that you can deal with the disagreement and not necessarily get in the way of that IEP moving forward. So parental rights in regard to an IEP. Schools have the obligation, like we talked about, but there are a couple obligations that are also there that parents have rights to. And one of them that I love is the clear offer. The clear offer just means that when you look at that IEP, when you read the minutes that they're going to deliver for services, or you look at that goal, you understand what they're intending to do, how to measure that goal objectively. You understand how much speech the student's going to get per week. You understand how much counseling or how much academic instruction. And the sort of linchpin of a clear offer is the ability to enforce it. If you look at the IEP and then were to look at the program and didn't understand how that translates over, then you couldn't enforce it. Aid support is a very common sort of clear offer issue. Supplemental support doesn't really tell us what that means. One-to-one support would indicate that the student has a one-to-one aid, but not all districts use language the same way. So you have to ask these questions and get it clarified in the IEP, so that if they say we're going to give you supplemental support, and you find out that the classroom ratio didn't change, but that they're going to pay a little more attention to your child, but you don't know what that means, you can't say you're not doing it the correct way. So when you read the IEP, if you don't understand something, make sure you ask. Now, one really important piece of that clear offer is that even if it doesn't land in the IEP where you expect the information to be, as long as it's in the IEP, California has a statute that says if it's in the IEP, it's there. It doesn't matter if it's in the place that you expect it to be. Parents have a right to request records. This is a right that I think parents don't always understand that they have. A lot of times they'll ask for an IEP or an assessment. It's important to ask for records, just to always have your best copies available, put them in chronological order, because when you're looking at, say, goals from year to year, you want to compare year to year. You can really see a lot when you go back 3 or 4 years and look at a triennial in comparison to a new triennial. So you can make a written request. A school district has 5 days in California to provide those records. Technically, it's copies of the records that you can go in and access them and make, but you can also receive copies. You can also ask for an explanation of parts of records you don't understand. And the school can charge families a cost. It must be reasonable. They can't charge you for the employment of people to go and find them, but they can charge you for the duplication costs. But if it's a hardship on your family, they need to give you an opportunity to explain that. And if it is a hardship on your family, they shouldn't be charging you for that. Assessments are a parental right. If there's a suspected disability or a need, the school has an obligation to assess, but a parent can also make a request. It's important, though, if you're making a request for an assessment, that you explain why you suspect that there's a disability or a need. The simplest way to suspect a disability is maybe a doctor told you, my son or daughter has autism. On the other hand, you might see an increase in behaviors that you didn't see before in the past. Those things would give you a suspicion that maybe something's not working the way it used to, and that your child's disability is changing over time. The obligation to assess for a school district is initial. So when we become aware of a student's need, California has a regulation that says that when a parent makes a written request for an IEP, that the school must assess for that child for an IEP. Similarly, if a parent makes a verbal request, that same statute says that the school should help them make that request in writing. Then once you're in the IEP process, you have to do a triennial, which is every 3 years. And the idea here is that information may not, go from year to year and develop the way we expect it to in the IEP. And it's a check and balance on the present levels, if you will, and anything new that might have arisen. You can ask for an early triennial. Typically, a rule of thumb might be if the triennial happened within 2 years, or the last assessments have happened with 2 years, you're still in what we call the statute of limitations. You can evaluate whether or not you disagreed with that assessment and still ask for an independent IEE. But on the other hand, if you pass that 2 to 3 mark, you might want to consider asking them to do the triennial a little early and explaining why you think it's necessary. There's also this idea that when an assessment is warranted, when there's a change of circumstance in some meaningful way that would require us to take a look at the student's needs a little differently. So a very typical when warranted sort of analysis happens when a student's behaviors fluctuate and they start rising, or maybe we see a new behavior that we've never seen before. It might warrant further assessment. And then, of course, before meaningful changes. So for instance, if you've met all your speech goals and the speech pathologist wants to remove speech as an area of need, that would probably require an assessment, because although the speech pathologist may be correct, the parent doesn't have that information to participate in that discussion. So they would want to assess the child, give the parent a report so that it can be discussed at a meeting and the parent can ask those questions. So how are assessments addressed in a 504 plan? When we got started, I sort of mentioned that a 504 plan also requires assessments. The regulations for 504 federally aren't real specific about what that means, but there's some indication in case law that those assessments should be very similar to an IEP. but informal assessments by themselves won't make it an invalid assessment for a 504 plan. They may be just enough to do academic, maybe do a light overview and hand the parent a page or two about the findings. That is something that is not well litigated in our field, and it could be a potential argument, but just getting that information alone might be helpful for determining eligibility and then doing that plan. So it doesn't necessarily make it wrong. Meetings and team members. Parents have the right to request a meeting. That those requests should always be in writing. The school district would have 30 days to hold that IEP meeting from the parent's request. And it must include the required and appropriate participants when you get to that meeting. Typically, a lot of people feel that I need the person that has relevant information to a specific area, but the law actually says that we need a special education teacher, we need a parent, we need a general education teacher to the extent the student might have some exposure to general education, even if it's speculative. And then you need people who might present a report. So if a report's been done, you need somebody who has knowledge of that field to present that report. It doesn't necessarily need to be the person that did that report. That person could quit and somebody else could step in. And then you need an administrator, somebody who is familiar with what the school has to offer or what that agency has to offer. And I sometimes, jokingly say that that could actually just be a special ed teacher holding a gen ed credential, provided with a, the permission to act as the administrator, meeting with the parent, because the parent is that other required participant. And you've got two people in that meeting that could carry that meeting out. And then, of course, parents can bring people who have specific expertise or knowledge of that student. And to me, that just means you can bring anybody who knows you and your child's needs to support you through that process. You can also record an IEP meeting. It's important that when you record an IEP meeting, California requires 24 hours written notice. So you could put that on the notice that they give you when you say you're attending the meeting. I intend to record this meeting. The school district has to allow you to record if you've given that 24 hours notice. They can also record the meeting. So if they pull out a recorder and you're recording, don't be surprised. But what about a 504 plan meeting? 504 plan meetings are a little bit different, typically held annually, but the requirements are nothing like IEPs. You could meet with a school psychologist and develop a plan, and you might get that plan 20 days later to consider whether or not you agree with it. It's a very loose process, and it's much harder to enforce. What about decision making? Well, when you develop an IEP, there are certain things that you have to do. The most important one is you have to meet the student's needs. And that's an important process to understand, because sometimes schools make decisions that are technically administrative decisions. And the big administrative decisions that schools get to make are with curriculum, the location of services, and the staffing. And so those all make sense. If you run a business, you get to pick who you want to hire, you get to pick where you want to put your business, you get to pick the tools at which you use in your business. But there are some situations where the student's needs are going to exceed that decision-making authority by the school. So for instance, if you had 3 placements and 2 of them could serve the student, but the third can't, but for space or for the amount of students that are in that third placing, they'd like to place your child there, but it won't meet their needs. They actually can't do that. They need to pick the location that can implement the IEP. Similarly, they have to address needs. And that's important, because if a parent has a want that isn't actually a legal need, then the school district might not address that want, but they do have to address the needs. So it's important to recognize what things the student needs and what things the parents hope for. You can advocate for things that the law doesn't require. And from an advocacy perspective, that's a wonderful thing. You can always get a team to do more than they're legally required to, but you won't get that from a judge if there's a disagreement about those wants. And again, an IEP team can do more than the law requires. So it's always important to keep those relationships really strong, to make sure that you're nurturing the communication, that you're asking questions and gaining insight to what the school's seeing. Because remember, they're spending 6 hours a day with your child. They're going to have a different impression to a large degree about how that child presents in the classroom. It's not home, different demands, different staffing, different structures. So be open to the idea that the information you're hearing is going to be different. And if you're skeptical or concerned, ask a lot of questions. An IEP requires consent. So again, an IEP team has to make that clear offer, and they cannot implement an IEP without that consent. So how much time do you get to consent? An IEP doesn't have a timeline for consent. When a school district and a parent reach an impasse where they cannot agree to move forward from something, there is a genuine disagreement. By law, technically, the school would have to file against the parent in order to meet the student's needs. But this particular aspect of the law doesn't always work out as well as we think it's going to. And so it's important to know that if you get to an impasse, you go get help. You figure out what's going on. A lot of times school districts will hold meeting after meeting after meeting trying to get buy-in. They don't want to have these arguments. They don't want to file for due process. So it's important to recognize that if you really truly reach an impasse, have the district make the offer or the charter school, and then you can deal with that issue. You could ask for prior written notice, which I think is on another slide, and you can use that to go get help. You can say, this is what the school is saying, that they're making this decision based on this information, and you can vet out whether or not that's reasonable. You can still disagree later, which means that you can give consent to an IEP and come back later and say, actually, I disagree with what the IEP is doing to meet my child's needs. And so like a rule of thumb that a lot of families use is if they're increasing the amount of service, you consent to the increase. But if they're decreasing the amount and you don't agree, you don't sign to consent to the reduction of services. So it's real important to consider that consent is about moving forward, not necessarily a statement about your agreement. Consent to some, but not all parts of the IEP, but just be careful. Be careful because you might be saying, hey, I consent to the services, but not the goals. And if the goals from last year, which would be what we call statehood, they would have to continue working on those goals and continue doing the things that they were doing prior to their inability to get your consent. So what you want to be careful of is that you're not leaving them in a situation where they have nothing to work on, but they have a service that they're going to present to the student, but nothing to do. I liken it to having tools to build something, but not having a blueprint for what you're going to build. So think through what you're consenting to and why. And if you're confused about it, seek some help. Advocacy, legal, doesn't matter. A lot of people are here to help. So make sure that you say, hey, I'm confused here. I don't know what to do, and get some help. The inadvertent removal of services is this idea that you might not check the box that you checked last year. And the most common box that I'm referring to is extended school year. Maybe it's, let's say, September, next June is a ways away, and the team doesn't discuss extended school year. And they don't check the box, but last year it was checked, and then nobody calls a new IEP meeting and there's no extended school year. You've consented to all of the IEP, so you've essentially consented to the removal of that extended school year. So the takeaway from this is just make sure you know what was in that prior IEP, and make sure that you're accounting for the things that maybe you don't discuss as much this year, but still may be necessary. And remember that when you don't consent to something, the concept of statehood, we're going to keep the IEP that was previously in place, that parent consented to, that the district's implementing. We're going to keep that going until we get some agreement in whole or in part. So procedures and implementations. Addressing procedural concerns, you heard me talk about it for a moment at the beginning, but procedural concerns are different than saying, I think this should be 30 minutes of speech a week, and the school is saying we don't need speech at all. That is what we call a substantive decision. It has to do with planning. But when you deal with procedural concerns, you're really dealing with a question about whether or not the parental rights have been interfered with, or the student's ability to access a service or advocate for a service is being impeded with. And a good example would be an assessment. You ask for an assessment for autism, and the school doesn't necessarily think that the child has autism, even though you may even have a diagnosis. So they don't agree to do the assessment. You show up at a meeting and they don't present that assessment, and they just say, hey, no autism here. We don't see anything that you're talking about. Well, now the parents' right to participate have been interfered because the information they're relying on is in the heads of the people on the other side of the table who have to make decisions, but the parent doesn't have the information to reflect on and ask questions. And the testing might come out with different conclusions than even those people subjectively believed. And then, of course, implementing, we're looking for that material failure. Implementing of a 504 plan, that's a little trickier. So while schools sometimes don't implement 504s and IEPs for their accommodations and modifications, the most common example would be a gen ed teacher saying, I don't think that's fair. I'm not going to do that. This does happen. We hear about it. On a 504 plan, your complaint process is different. It doesn't really have a huge amount of impact on the school changing their ways, if you will. On an IEP, that may be different. But implementing accommodations and modifications is also tricky with an IEP. It's much easier to show that they didn't do something in an IEP than they didn't carry out a 504 plan correctly. A 504 plan, we're going to look for impact. We're going to look at the grades per se. But we're not going to have the same sort of progress on goals to look at, to ask, are we seeing the anticipated progress we would see on the IEP? Which, going back to records and making that request and keeping good data about your child, when you want to show implementation, you really have to look back and see, do we see the anticipated progress? Did the school do the things they promised to do over time? And what actually caused that lack of progress? Because a lack of progress doesn't necessarily show that there was any wrongdoing by the school. It might just show that the student's disability is just really difficult. And in order to establish that access to education, they have to do a lot. And it's harder than we all thought it was at the time that we did that planning, because we're looking at reasonability. And if they made a reasonable plan, but we didn't get to the outcome, that's probably going to be okay in the law. All right, so handling concerns. What do you do if you have a disagreement? The most important part of this is to stay composed, whether you're in person or whether you do this in writing. It's really important, though, if you're going to seek help later, that your concerns are in writing, because conversations get lost. People don't remember things the same way. They may just disagree. They may flat out say you never had that conversation. So if you have a conversation with somebody, you might want to follow up with an email and just say, hey, thanks for talking to me about X, Y, and Z. Discussing concerns at an IEP meeting, make sure you record that meeting. Those notes will never live up to the conversations you had in the meeting. They're written by the school. They're written fast. While a lot of conversations happening, they might not be the same points that you think are important when they're writing down those notes, whether it's a team action or a meeting notes. So just make sure you're recording that meeting and that you're discussing your concerns. You can ask specifically for your concerns to be added to typically the present levels under parent concerns, or ask them to write something specific in the notes. But if you leave a meeting, you can ask for prior written notice. We had a disagreement. The school wants to do or not do something that I've asked for. So can you provide me this document called prior written notice? And this just means that they're going to outline the reasons they're saying yes or no to something, what they relied on to get there. And that's going to give you a piece of paper that does a couple different things. My favorite thing that it does is it says what their position is. And so that can be evaluated. But it also gives you enough information that you can go get help and ask, is this reasonable? Now, an IEP by itself can contain prior written notice in it if it lives up to the standards that prior written notice is supposed to have. So if you have an impasse or a disagreement at an IEP meeting and they write a lot of information about how they came to their decision and it meets the requirements by law of prior written notice, then they wouldn't have to issue a separate letter. The important sort of takeaway here is create documentation. You want to make sure that the things that are going on are things you can reflect on later and explain. And that's sort of the big piece, the explanation. Handling 504 plans, that's a little different. We don't have the same administrative law piece to it. We can't go to a hearing and present evidence to a judge the same way. But there is a compliance process that happens with 504 and the Office of Civil Rights, where you can file a compliance complaint. And that does make a 504 something that you can pursue, that you violated the rights here or didn't do something you promised to do. But it's a lot different. the things that you put in writing are going to help you when you have to hand that over to explain how things happen. And if you had a really rough potential 504 claim, something terrible happened, and you did file a federal complaint, you still don't have that admin process, but you're going to need to prove things. You're going to have to prove both the violation and the damages that were done. So you're going to need a lot of documentation. Point being is, in handling concerns, you want to stay composed. You want to be the most reasonable person in the room. You want to ask and create written materials that explain what's happening. So when you have a disagreement, avoid the argument, document the disagreement, and ask for that prior written notice. And again, why do you want to do that? You just want to make sure that that conversation isn't something that can be a huge disagreement or difference of opinions. You want to make sure that you've documented things so it's clear what you're having your disagreements about and that you can go get help. So there's a number of complaint processes that families can use. At the school level, there's a thing called an Education Code 220, which is basically an internal investigation, a complaint saying something is wrong. Typically, these are done where the teacher is maybe rude to a student. We see a lot of these types of complaints. Typically speaking, these are investigated by the school, handled entirely by the school. It's likely that they're going to come out in favor of the school. I've seen the opposite happen from time to time, but if I'm managing somebody, I'm probably going to defend them in the management of them because I'm going to support my staff. So, just be mindful that when you file a 220 complaint, if that's what you're doing, that you provide documentation so that you can show that these things happened and that somebody on the other side of the table can't say that it just didn't happen and therefore they rely solely on that information. A lot of schools are doing alternative dispute resolution. This is a semi-informal process. This is something where you might land yourself in a settlement agreement with the school, but it doesn't typically have attorneys involved. Usually the school district or a charter school may be advised by attorneys in the background, but it is meant to sort of stave off complaints that are more formal, that might create a situation where the California Department of Education is looking at sort of what happened here and saying, hey, here's a mark against the school district. So ADR, as we call it, is a good option for some families. But if it gets into a situation where maybe you don't know what the remedy or the outcome should look like, or you have a complex problem, you might want to get help, and it might lead you away from the ADR solution. But it is a good solution. A lot of school districts are doing this now. It's resulted in a lot of good outcomes, but it is not the only way to do things. A compliance complaint is saying that there's something procedurally wrong. So they didn't comply with their timelines. It would be a California Department of Education complaint. But you typically wouldn't send a complaint to the California Department of Education over a disagreement about how much speech or how much academic instruction. That's going to be very hard for them to go and investigate and determine on their own whether or not an IEP team made a decision. So they don't do that. 504 complaints would typically go through the Office of Civil Rights, and they do something similar to the California Department of Education and how they investigate, and then they write a written report. Neither of these processes require a hearing. The IDEA does something different because in order to shorten the timeline of the complaint, they've created an administrative process, keeping in mind that if you went to a federal court and spent 2 years litigating, that would take a lot away from an education. So the timelines are much shorter. In fact, when a complaint is filed in the due process realm, which you have up to 2 years to file from the date of the concern that you're having, now that's going to move really quickly, so much so that within the first 15 days of the filing of that complaint, the school needs to informally meet with you and determine if they can resolve the case. Within 45 days, they're supposed to have a mediation. Those dates tend to get kicked out. So if you happen to be in a due process at some point, just know these dates extend. They could extend up to a year, depending on what's going on typically. So these don't run as quickly as I think the law intended them to do, but they do run very quickly in terms of other areas of law. So due process is sort of the administrative piece for the IDEA. 504s would go through that OCR process. Typically, they could go to a federal court if they're kind of egregious, if you will. And if you're just having a small thing, like maybe they didn't grant your IEE and you've been waiting a year, well, that would be procedural. You could file it with the CDE and say they waited too long to file for due process or grant that IEE, which we haven't talked about, but that would be the kind of CDE complaint you might do. So if you want to preserve your rights, though, you got to document everything. The last 3 or 4 slides, I've talked a little bit about why that's so important. If you're going to be able to resolve a dispute, you're going to need to prove where you're at. An analogy might be if you're going to go to a store and try to return something, you're probably going to need a receipt. You want to be able to show what you're dealing with. And if you are that person that has kept good documentations, you've been very reasonable, you might not have to go that far. You might go to the special education director and say, here's my last 5 emails dealing with this issue. You can see, I've worked really hard, but I don't feel like I'm being heard. And they may read that and say, wow, mom or dad, they're being super reasonable here. I want to help you solve this problem. So document everything. And then, of course, if you need help, go seek out an advocate or an attorney. I mean, it's that simple. The advocates and the attorneys in our field are very open to helping families. In fact, 99% of the people that work in this field work because they have some personal touch on this field. They have a sibling, or they have a friend, or they worked in it and really fallen in love with the field. They want to help. And I say that so that if you're feeling like intimidated to speak to an attorney, or possibly have a difficult time figuring out if you want somebody to come to a meeting, an advocate, go have the conversation. There are different advocates and different attorneys for different people. There are people that are more aggressive, less aggressive, more reasonable, less reasonable. But at the end of the day, you match up to somebody you feel is going to fight for your child's rights in a meaningful way, hopefully maintain the relationships and get you on a different track so that you're less arguments and your child's learning. So be open to getting help if you need help is really the message here. And with that, we're at 8:21. We have about 10 minutes left, and we're at our questions. And I haven't been looking at our webinar chat too much for the Q&A, so I am going to rely on Amanda here.
And there's a few questions in here. So what happens if you think your child needs more than they're receiving? So I have one parent here who said their son has a 504 plan, has some physical impairments, and doesn't socialize with his peers, but the school and school district is saying a 504 is enough. So what do you do when you disagree?
So one of the really big issues that we have in special education has to do with educational impact. It's this idea that we have to determine what the manifestations of that disability are and how it's actually interfering with the student's access to education. And when I use the word access, it's not just academics. It could be social emotional, it could be behavioral, it could be mobility around campus, for instance, and that sort of description that Amanda just gave me. And that's a really important distinction, because when you talk about these things with the school, not only do you have to say what the student's doing, but you kind of have to explain how it impacts them at school. So if a student's having a problem with their hand, for instance, and this is a very generic description, but they can't open or close a door, they're going to need some help. That's pretty obvious. Everybody's going to know that if the student can't open the door, there's a need there. And if it's related to a disability, then they're going to have to address that through either a 504 or an IEP. Now, on the other hand, if you simply say, I just don't think there's enough speech, or I don't think you're doing enough counseling, that's probably going to fall on deaf ears to some extent. They're going to think, but why? And so if you can answer the but why question, you're much further along in this discussion with the school, and you'll probably be heard. If you feel like you've done that and you're not getting the results that you've anticipated, then you should get some help. You should have somebody who's looked at a lot of IEPs, talked a lot about this area with people, understand all the lingo, if you will, and they can help you sort out whether or not this is reasonable or it's being articulated correctly, or possibly the process needs to be treated differently. Developing present levels, for instance, leads to goals. If you fail to identify an area of need in present level, there's a chance that the team will just not address that at all because it doesn't exist in the first part of the IEP when you get to the second part.
Great. And a follow-up to that is, how do you know when they're actually following the IEP as it's written, right? I think I heard you say earlier asking for records, but how do you know?
So good communication with your school is just paramount in everything you do. Um, the simple answer is, when I said implementation earlier, I said it's the hardest thing to really address and prove. Uh, Implementation is hard because you're not there. You can do an observation, but you might observe on a day that it's just a bad day for the class. Maybe somebody didn't show up and you think, ha, I got you. You didn't have a speech pathologist. You never had one. Well, not having one today doesn't mean they never had one. So by listening to your child, obviously, if your child's verbal and can express, I didn't see somebody this week, the right way to do this is to go back then to the school and say, hey, I just want to check in and see how this service is going, and maybe speak to the speech pathologist about what they're seeing. And my son or daughter mentioned that they didn't see the speech pathologist this week. Can you tell me a little bit about that? If you can turn this into a casual conversation, you will get honest answers. And for the most part, even if things aren't happening quite the way they should, that doesn't mean they're legally in violation. The answer might just be pragmatic. It may be an issue where, somebody had a flat tire on the way to school. So ask a lot of questions, but do it in a really nice manner. And you'll find that you get a lot of information. On the most extreme side, I have had friends who are advocates ask at an IEP meeting, why something's not working. And they've told them, we're violating the law. We don't have what we need here. And that's been on tape. And that's because they had a very open, honest conversation. And schools want to serve kids. I believe that wholeheartedly, but they have limitations that we don't see when we're looking at the school wondering why things aren't happening. So if you can develop that communication and understand where they're coming from, you'll get the information you're looking for. But be patient.
I love that. Yeah, we have to really be a team, like you said, and not just, give me, give me, give me, right? Be a team, really understand where they're coming from. Understanding your rights is what I'm hearing, and document, document, document. Can you give some advice on, besides documenting the conversations, what other advice do you have for parents to, or what information sorry, what other things should they be documenting? One of the things I learned from a different advocate is documenting, regression, in terms of like social skills, like this is what's going on. Any other advice there?
I think documenting regression is an interesting one. It's not what I would have talked about, except you mentioned it. And what I love about that is a lot of times that when families tell me a student has regressed, they often do it based on a score. And so if that score on, say, Woodcock-Johnson is a 70 this year, and then 3 years later, it's a 69, the assumption is that the student dropped 1 point. But they've also been, the score has been normed to a different age, and they could still be making progress. They've just made it slower than they potentially had in the past. It's not a perfect analysis in the way that I'm explaining it, but it might not be regression. So I avoid conversations like that when I start saying, hey, my child's regressing at school, because I'm not sure I have enough information objectively. I would ask for an assessment first. I believe that my child's falling behind a little bit more than we had anticipated in the past, and I'd really like some objective data to do this, and I don't believe the progress report's doing that. Can we do an academic test? So I'd kind of go that route. But in terms of like documenting things that are a little different, my absolute favorite one has to do with students that don't go to school or are being asked to be picked up. So if you're keeping your child home from school and it's because of something that's happening at school, you need to make sure you tell them. So it would be a quick email. Hey, my child isn't able to get to school today. They're anxious, dysregulated. And when I, walked my son out to the car, my son had a breakdown. I don't know what to do. Is there anything you can do to help? Because now you're creating the educational piece. This is impacting education. This is caused by education, and you're documenting day by day. I wouldn't go 5 days out of school and send one email. I do one email for every day. Similarly, if the school is calling you up at 12 o'clock and saying, you need to come get your child, And a lot of times families will say, well, I went and they didn't give me suspension paperwork, or there was nothing in writing except I signed the book. What I like families to do is send a quick email and say, thanks for giving me a call. I'm on my way to get my child. If you could have any kind of suspension paperwork or a description of what happened, I'd really appreciate that. It doesn't even matter if you get it, because you've sent the email that indicates that I'm picking my child up because you asked me to. And so sometimes you have to find different ways to present that information, because if you do it the other way, I don't want to pick my child up, don't send them home, which you actually can do as well. You want to make sure that you're doing it in a way that's tasteful, that isn't going to sit negatively with people and create conflict.
Great. And we only have one more minute, but we did have one last question come in. She said, we have an initial evaluation meeting where a key evaluator, which was the hearing specialist, was not invited despite her daughter being diagnosed with hearing loss. And they made this request repeatedly, no response. Eventually had another evaluation with the appropriate evaluators present, IEPs this week. Any advice on how to navigate this awkward situation?
So we had eventually had another evaluation with an appropriate evaluator present. I feel like I'm missing a little bit of facts. So to sort of go backwards and try to answer this question, if the key evaluator was not presenting a report, then they're not necessarily a required member. The desire to have somebody in a meeting doesn't make them a required member, the law does. And so if they don't honor the request to bring somebody who's not required by law, they're not technically violating the law. So now, if they were presenting the report, but the person that you wanted to present the report wasn't available, so somebody else did it who had the requisite knowledge and credentials, that would be all right. So they could do it that way. But what I guess I'm a little struggling on is the sort of other piece of that. You had another evaluation, an appropriate evaluator present. I don't know if these are independent, if they're district paid for assessments. I don't know if you met prior and would like the person to come back. There's just too many little nuances to really give you a great answer on that. You'd probably want to seek a little bit of help to see how to handle that. And with an IEP meeting coming up in just a few days, because it's this week and we only have a couple more days left, you might just want to give a call over to either a law office or an advocate and just give them a little bit more factual information to sort of work through that with you.
Awesome. Well, I want to thank you again, Seth, and everyone else who took the time to be here today and learn. I definitely learned a lot in this presentation. I thought I knew it decently, but wow. So I appreciate you really sharing your knowledge with the community. A reminder to everyone, we are going to share this recording as well. So and I see Seth's contact information here, and it will also be in the follow-up email that we send you. So please reach out to him and reach out to Brain Balance if you have any other questions and wanting to learn more about your rights or wanting to set up any different kinds of assessments. We have a lot of other community partners and resources that we can share as well.
Well, thank you, Amanda, for having me tonight. And I hope this information is helpful to everybody. Remember, a good broad understanding of the law will go a long way. You don't need to get into the weeds as much as you need to have a good, solid understanding of how things operate and a really good recognition of how you're going to work through that process.
Awesome. All right. Good night, everyone.
Thank you for coming.